All right. Hello. Welcome back. We've got another fun filled episode of Delete Lawz. Well, DeCastro versus Abrams et al. And Google has officially entered the fray. And I've got to admit, when I first glanced at today's filings, I was disappointed. I was very disappointed. And I'll tell you why I was disappointed. Well, as we discussed a couple episodes ago, and well, a couple times at least. So Google is represented by Wilson Sonsini, which is one of the best law firms there is. It's a massive law firm. They only hire the best law students, only the best lawyers. Like I said, here in Salt Lake, they just recently, like in the last year, opened an office, and like literally they've only taken the number one student from each class, number one student from my class, number one student from the class behind. I mean, the dude from my class, he was a partner at the best local firm. He's now an associate at Wilson Sonsini. But so basically, I was expecting, as frivolous as this is, I was expecting to see the Mona Lisa of 12b6 motion to dismiss. Just beautiful legal writing. That's not what we got. So just looking at the title, I was disappointed because I've got the docket open. We got a notice of appearance from Matthew D. Gorman on behalf of YouTube, Google LLC. Now, Mr. Gorman is of counsel at Wilson Sonsini, meaning he's neither an associate or a partner. He's counsel. He's a lawyer. But so his JD is from NYU Law, top 5 or 6 law schools in the country. His Bachelor of Science is from Cornell, Ivy League all the way. Obviously, he's got to be, at the very least, either very smart or a very hard worker, but probably both. So I was expecting good things. But we get a motion for extension of time. But it turns out that that's exactly what was needed here. So, way back when I was in law school, I can't remember which of my professors to attribute this to. It's not a direct quote, it's paraphrasing. But what are the skills necessary to be the best trial attorney, the best litigator? Now, obviously, you want to be a good writer, you want to be a good orator, but those aren't the most important skills, because the best trial attorneys are the masters of the federal, well, and state, but the rules of evidence, because if you control the evidence, you're controlling the trial, but also the rules of civil procedure. Because, well, for starters, so much of discovery is through the rules of civil procedure. So if you control discovery, you control what the other party knows. But so if you control procedure, you control everything. And actually, I do remember, and it's not a direct quote, but it's my civil procedure professor quoting the late Michigan Congressman Dingell. I can't remember his first name. His daughter, Debbie Dingell, has his seat now. But he was referring to controlling the procedure in the House of Representatives. So, but the same applies to lawyers, especially trial attorneys. And so, why do I bring this up? Well, I think we've got to go back almost to the beginning, at least of this lawsuit. And we have docket number 16 from the 18th of October, filed by Benjamin Wish, the emergency motion for a hearing for a status conference by Kate Peter. And we're going to look at Exhibit A, which is attachment 1. And this is an October 12th email from Delete Lawz to Benjamin Wish, where things are a little out of order. But so Benjamin Wish emailed Delete Lawz not first, but for our purposes. You mentioned, dear Mr. DeCastro, you mentioned in a prior email that you intended to file an amended complaint. When do you intend to amend? I'm just trying to evaluate whether we should put together our answer now or await your amended complaint. And Delete Lawz, being the petulant child he is, and thinking he is in charge, he controls the process. This is his world. We're all just living in it. Responds, you can go ahead and respond to my original complaint. There's a process here, and we're going to follow it. So basically, we know from hindsight that the amended complaint completely altered the cause of action, changing it from defamation to copyright infringement. And the reason he did this is he wanted Benjamin Wish for Kate to respond to 2 completely different complaints and charge her for the privilege. And so Google, well, I should say Mr. Matthew Gorman, as any decent attorney would have by now, has, I'm sure, reviewed the docket. I'm sure he has seen this email, and he has seen that the cause of action changed. So I'm not going to fault Benjamin Wish for not doing this, because at the outset, he wouldn't have known what was to come. Mr. Gorman has seen it. He has experience. Well, he at least has evidence of the games that Delete Lawz plays. So, being an excellent attorney, being an excellent litigator, he says, you know what? I'm the expert at the federal rules of civil procedure, not this clown. So we're going to play by my rules. And I think it helps that he's already seen Judge Burroughs has already done something similar. Because, yeah. So first, of course, we do have the notice of appearance where Matthew Gorman appears as counsel for Google. Easy. But here, and I've only read the first paragraph roughly of this, but that's when I realized, you know what? This is actually excellent lawyering. Because when I first saw the title, I felt blue-balled, because, like I said, I thought we were going to get a brilliantly worded 12b6 motion. But then I thought, how can an excellent lawyer like Mr. Gorman not have had enough time to respond to this train wreck of a complaint? It's not that he hasn't. Because let's read it. So, defendant Google LLC motion and memorandum of reason for extension of time to respond to plaintiff's forthcoming third amended complaint. Well, that's something that wasn't in the title, in the docket, but that gives it all away. To respond to the forthcoming third amended complaint. Because remember, let's go back to the docket. Scroll all the way back down. Docket number 102. Judge Burroughs has granted plaintiff's motion to file what she's calling a second amended complaint, but even though it was styled as asking permission to file another supplemental complaint, and it's all confusing. But and this is the same docket. I said the judge has now seen the games he plays, and defendants nonetheless, or defendants need not refile their motions to dismiss unless ordered to do so by the court. So that's her saying, yeah, if your existing motions to dismiss are enough to dismiss even after this amendment, I'm going to dismiss. You don't have to do any extra work. But if I order you to respond, then you should. So Mr. Gorman has seen this and he realizes, hey, the judge is pretty much putting things on hold until he files this new amended complaint. So defendant LLC, by and through its undersigned attorneys, respectfully submits this motion and memorandum of reasons for an extension of time pursuant to Federal Rule of Civil Procedure 6B1A. Let's look at 6B1A, which, funny enough, I don't think we've looked at Rule 6 yet, have we? Well, 6B is extending time. In general, when an act may or must be done within a specified time, such as an answer, the court may, for good cause, extend the time, with or without motion or notice if the court acts, or if a request is made before the original time or its extension expires. So, for good cause. Well, good cause would be, hey, dumbass has signaled he wants to file another amended complaint. So it would be good cause to not make us respond or answer until after he's done so. Why do something twice if we should only have to do it once? That would be in the interest of justice, in good cause. So Google seeks an order extending its time to file an answer or Rule 12 motion until 30 days after plaintiff files his forthcoming third amended complaint. See ECF numbers 101 and 102. To that, Google states follows. Background. On December 2nd, 2022, plaintiff Jose Maria de Castro filed his original complaint against defendants Kate Peter and Joshua Abrams. On October 3rd and 5th, 2022, the court extended defendants' time to respond to the complaint by 30 days and 29 days, respectively. ECF numbers 7 and 9. So that's Mr. Gorman saying, hey, look, you've already extended. It's already tried and true practice in this case. Of course, that was for an entirely different reason. It was 21 days to shop for an attorney is a small amount of time. It really is. I mean, I know Delete Lawz in his opposition to those motions, well, letters construed as motions. Wine. There are plenty of qualified lawyers in Boston. It's asinine, and they don't have a right to an attorney anyway, so you should deny it. And it's like finding an attorney who is willing and able to take the case, competent in that area, and within your price range, that's a tough task. It takes a while to shop around. So, but it's the same. This shows that there's already a pattern by this judge in extending time when it's for good cause. So on November 16th, 2022, plaintiff filed an amended complaint against defendants Peter and Abram, ECF number 62. On December 1st, 2022, plaintiff moved to file a supplemental complaint, ECF number 76. Court granted the motion the same day, construing it as a motion to file a second amended complaint, ECF number 77. The court also granted defendants Peter and Abrams an extension of time to respond to the second amended complaint. So that's both two important things. Number one, the court has granted extensions for responding, extensions until after the filing of an amended complaint, which is what Google's asking for. But it's also showing, hey, look, this moron has been filing amendments left, right, and center. So, don't make us respond yet. On December 2nd, 2022, plaintiff filed his second amended complaint styled as a supplemental complaint, ECF number 79. The complaint purported to add Google to the caption as a defendant, but did not attempt to state any claim against Google, list any counts against Google, or include a prayer for relief against Google. To the contrary, the complaint ended after the factual background section. Well, hang on, Mr. Gorman. That's sounding an awful lot like a 12b6 claim right there. Failure to state a claim. This isn't a 12b6 motion. Come on. I mean, but as I've said, repeat it early and often. Keep it in the back of the judge's mind, or even at the front of the judge's mind. I've said it about the I don't care if I win or lose, I want to cost them money claim. But, for this, it works too. Plaintiff sent Google a waiver of service of summons form dated December 3rd, 2022, which Google signed and returned, ECF 99. Accordingly, Google's deadline to answer or otherwise respond to the second amended complaint is currently set at February 1st, 2023. So remember, we just looked at rule number 6 of the Rules of Civil Procedure, and it said, for good cause, if the request is made before the deadline to respond. So, deadline to respond, February 1st. This was filed 24th of January. So, it's a full week before the deadline. So, that satisfies that prong of Rule 6. Beginning in early January, lead counsel for Google in this case experienced an acute illness from which he is now recovering. This resulted in a delay in drafting Google's planned response to the second amended complaint. Well, sounds like Delete Lawz is kind of bailing him out on this a little bit by, playing games. Although an acute illness, especially if it's a certain, 3-year-old plague, the judge would probably grant an extension for illness anyway. But that's not as guaranteed. On January 11th, 2023, plaintiff moved for leave to file another complaint, styled as a second supplemental complaint, ECF number 101. Google's understanding is that plaintiff's next complaint would in fact be his third amended complaint, but would welcome any clarification by the court. Yeah, there's the water is very muddy on this point because it's been called an amendment or a supplement by multiple parties, and they are different. See my previous video. Plaintiff's motion did not attach a proposed amended complaint or state a time frame within which he will file one. The court granted plaintiff's motion the next day, but did not specify a time frame within which he must file his next amended complaint, ECF number 102. Google initiated a meet and confer call with plaintiff on January 18th, 2023, which the other defendants have not been doing because Delete Lawz is such a pain in the ass that the court excused meet and confer sessions because he's a dick. He's intentionally a dick, and the court realized very quickly that it was just a waste of time and money and an added aggravation. So Google initiated the meet and confer on January 18th and sought his consent to extend Google's time to answer until after plaintiff files his forthcoming third amended complaint. Plaintiff declined to give consent. Imagine that. It's almost like the Exhibit A from Docket 18 that we looked at to start. He wants to cost them additional money. Instead, plaintiff stated his intention to wait until after Google responds to the second amended complaint so he can evaluate Google's position before filing his third amended complaint. Google communicated with defendants Peter and Abrams through their counsel of record on January 23rd, 2023. Defendants do not object to the proposed extension of time. This is Google's first request for an extension of time in this case. Argument. Good cause exists to extend Google's deadline to file an answer or a Rule 12 motion for 4 reasons. First, the extension would not prejudice any of the parties or affect the court's timeline for deciding any of the pending motions litigated between plaintiff and defendants Peter and Abrams. Second, granting Google an extension would be a welcome act of forbearance considering lead counsel's recent illness. Third, an extension for Google would be consistent with the extensions the court has granted to the other defendants. See ECF number 7, 30-day extension for defendant Peter to respond to complaint, and ECF 9, 29-day extension for defendant Abrams to respond to a complaint. ECF number 77, extending time for defendants Peter and Abrams to answer forthcoming second amended complaint until 21 days after it is filed. Finally, Google cannot move to dismiss the third amended complaint before it is filed, and it would be needlessly inefficient for Google to attack the incomplete second amended complaint when that complaint is soon to be superseded. See General Federal Rule of Civil Procedure 1. Well, let's look at Federal Rule of Civil Procedure Rule 1. If it wants. So, Rule 1, scope and purpose. Once it loads, this website is so slow. So, the scope and purpose. These rules govern the procedure in all civil actions and proceedings in the United States District Courts, except as stated in Rule 81. They should be construed, administered, and employed by the court and the parties to secure the just, speedy, and inexpensive determination of every action and proceeding. So, if the court and the defendants know that the plaintiff is going to file another amended complaint, is it just to require them to respond to two instead of to just the amendment? No. Is it inexpensive to respond to two motions to dismiss instead of one? No. Is it speedy? No. Because then you have to wait for an additional response deadline, and it's a total mess. So if the purpose of the rule of civil procedure are to secure the just, speedy, and inexpensive determination of every action and proceeding, well, then you have to keep that in mind in determining motions based on every rule of civil procedure. So a Rule 4 extension for more time, well, that doesn't sound speedy initially until you realize, oh yeah, it is. So based on Rule 1 and Rule 4, it should be granted. And also mentioned by Google. It's consistent. It's consistent with the extensions the court's granted already. So the plaintiff is expected to state his claim before the defendants answer it, and his pro se status does not relieve him of the obligation to comply with applicable rules. Citing Collins v. Federal Express Corporation, which is from the District of Massachusetts, 2021. See also McNeil versus Stewart Healthcare from 2019 in the District of Massachusetts, which states, pro se plaintiffs are obliged to comply with the federal rules of civil procedure, including the requirements of Rule 8 and 9. Wherefore, Google respectfully requests that the court grant and issue an order under Federal Rule of Civil Procedure 6B1A. I said Rule 4 a minute ago. I meant Rule 6. Extending its time to respond to the complaint until 30 days after plaintiff files his forthcoming third amended complaint, dated January 24th, 2023, respectfully submitted Google LLC by its attorneys, Wilson, Sonsini, Goodrich, and Rosati, signed Matthew D. Gorman, and Benjamin Margo, Pro Hoc Vice, forthcoming. He's out of the New York office. He's the one that sent in the waiver. So he's the one. They're both NYU attorneys. Benjamin Margo, Harvard undergrad. Matthew Gorman, Cornell undergrad. So, but yeah, and this is a very good point, though. The plaintiff is expected to state his claim before defendants answer it. It's asinine. It's absolutely asinine that they asked him to consent to the extension. He said he wants to wait until after Google responds so he can evaluate Google's position before filing his third amended complaint. That's not how this works. You file your complaint. You state your cause of action. You don't generally say, yeah, I think Google's done something, and not even allege a cause of action, much less any facts to support the cause of action. Remember our good friends Twombly and Iqbal. But you can't file a lawsuit and say, I'm suing Google, and that's it. And then say, well, it's okay that this is deficient because I plan to file an amendment, but only after Google tells me what's wrong with it. That's asinine. That's not how this works. I mean, is he seriously this stupid? Well, yes, he is, but he's so aggravating. So aggravating. So that's what we have now. And like I said, at first I was disappointed. I felt blueballed, but this was excellent lawyering. That it's just excellent lawyering. There's no argument. So any initial disappointment was replaced by a contact high, but it's nice to see. I look forward to the incomprehensible gibberish nonsense of Delete Lawz responding to it, of course. So, with that, this is still in the realm of being short and sweet, 31 and a half minutes right now. So, and as always, I forget to do this at the beginning, but please like, subscribe, share, do all the fun YouTube-y things. And thank you for joining me. I will see you very soon, I'm sure, for the next one. With that, goodbye.